Hello and welcome to the Kenneth Ricamon Law Office Legal Podcast, the NJ Laws Tube. In this edition, we're doing our program from the New Jersey State Bar Association annual meeting in Atlantic City at the Borgata. And we're talking about recent cases affecting municipal court and criminal cases. In this edition, we're going to talk about the first 8 cases, and starting with number 1, DWI. The police officer reads the paragraph 36 statement that the defendant must take the breath test and that they have no right to speak to an attorney. In 1987, State versus Levitt, there was a recognition of the confusion doctrine. Well, what if the defendant doesn't speak English at all? Well, tough luck. In State versus Marquez, 408 N.J.S.A, the appellate division in 2009 held that the refusal to take the breath test stands even if the driver does not understand English. And then there was another case that was also decided, State versus Kim, that said the fact that the person speaks Korean rather than English, that is not a defense either. So that's State versus Marquez and State versus Kim. 2, drug cases. The New Jersey drug statute permits a lab report to go into the evidence if there's not a timely written objection by defense counsel, and that has been upheld by New Jersey courts. What's the Supreme Court position on this question? And the answer is non-admissible. The case of Melendez-Diaz versus Massachusetts, 129 Supreme Court 2527 2009. The U.S. Supreme Court rules that the lab report is non-admissible in a criminal case because to admit it would be in violation of the defendant's Sixth Amendment right to confront witnesses against them. So the state would be required to bring the lab technician in. 3, careless driving and speeding cases. The statute itself in careless driving does not set forth the judge being able to suspend a license. Speeding, the statute does not permit a judge in the statute to suspend a driver's license. Can a judge suspend a driver's license then? The answer is yes. State versus Miranda, 408 N.J.S.A 412 Appellate Division 2009. The judge can suspend a driver's license for a traffic offense even if the statute is silent on that issue. The court can use 39:5-31, which authorizes without standards or limits a driver's license suspension for willful motor vehicle violation. And that was State versus Miranda. 4, in a gang neighborhood, that's at a traffic stop, is a pat-down permitted of a passenger if there's not a report of a weapon ahead of time. And now, let's say the answer is the pat-down is not prohibited, the pat-down is permitted. In Arizona versus Johnson, 172 Lawyers Edition 2nd, 694. In this case, the police were traveling in a gang neighborhood where the crisp gang was prevalent. The police were in a task force and they stopped the automobile for a motor vehicle violation. The officers had no reason to believe that any of the occupants were engaged in criminal activity, but the one police officer looking at the backseat passenger, that person had gang clothing and appeared nervous. The passenger was from a town where the crisp gang was, and the defendant had been in prison. So the officer asked that defendant person to get out of the car to question them further, and then found a gun. So the Supreme Court said under those circumstances it did not violate the Fourth Amendment's prohibition on unreasonable searches and seizures. And that's Arizona versus Johnson. Let's see. Number 5, continuing with our cases, can a defendant who pled guilty withdraw the plea? And the answer is yes. Now, sometimes defendants in jail want to withdraw their plea because they get advice from someone else locked up who had their GED, as opposed to an attorney who might have went to a good law school. The case is State versus Slater. 198 NJ 145 2009. Judges are to consider in balance 4 factors in evaluating motions to withdraw a guilty plea. 1. Whether the defendant has asserted a colorable claim of innocence. 2. The nature and strength of the defendant's reasons for withdrawal. 3. The existence of a plea bargain. And 4. Whether withdrawal could result in unfair prejudice to the state or unfair advantage to the accused. In the Slater case, the defendant met their burden and was permitted to withdraw their guilty plea. And that was State versus Slater. Let's see. Number 6, Miranda cases. Let's see. And this case deals with whether police need to re-administer a Miranda. In the next case, called Nehammer, the defendant's Nehammer is called by a police investigator. Says, listen, we're investigating a complaint regarding another guy. Can he come down and provide some information? So the defendant goes down to the police, is given his Miranda warnings, and then they take a statement from him regarding this other person. And then Nehammer said, oh, by the way, there's some accusations against you. What do you want to tell us about that? Let's see. Question starts again. There's no re-Miranda. He was given his Miranda before being questioned about the other guy. Is the confession admissible? And the answer is yes. Police, in this case, did not need to re-administer the Miranda warnings. That's State versus Nehammer, 197 NJ 383 2009. 7. DWI cases and defense experts. Let's see. Can the court order a sequestration order where different witnesses have to stay out of the court and not talk to each other apply to a defense expert? And the answer was no. In State versus Popovich, 405 NJ Super 392. In this case, the defendant's conviction was reversed. The appellate court said the trial court erred when it ruled that defendant's expert was subject to the sequestration order and would not permit the expert to watch the trial testimony. And that's State versus Popovich. Number 8, major case. Can police always search a car under community caretaking or inventory or automobile exception? And the answer is no. State versus Penaflores, there's no automatic automobile exception. And the Supreme Court also approved in the future telephonic search warrants. And the case is State versus Penaflores, 198 NJ 6 2009. I'd say, the court said in the future there could be telephonic warrants, and there's currently a task force looking into how those should be done. And again, that's State versus Penaflores. For additional information on relevant criminal cases, visit website njlaws.com. That's njlaws.com. Or website benotguilty.com. That's benotguilty.com. Or call the law office of Kenneth Verkaman, 732-572-0500 at 2053 Woodbridge Avenue, Edison, New Jersey. Thank you, and in our next edition, we'll go over additional recent cases. Thank you.